Once the parties have had a full and fair opportunity to litigate their claims, the game is over. There are no second chances. It doesn't matter why you want to relitigate or how good the excuse is. Just like your mother when you were 5 years old and you want your 5th cookie for the day. The answer is no. Importantly, it doesn't matter whether the prior litigation brought out all of the issues. When someone wins at litigation, he wins on all of the issues in defense that were brought or that could have been brought on that claim. To be clear, it does not matter which issues were actually litigated in the first litigation, just that a judgment on a claim was reached. Let's say that Rebecca and Rachel have a contract dispute. Rebecca wanted $15,000 and the jury awards her just $5,000. A year later, Rebecca sits down with her new attorney to talk about the case. In the middle of her telling her story, he jumps out of his chair and finds a book of statutes and shows her a statute that would have guaranteed her a recovery of no less than $50,000. Too bad. Her chance is over. She might have a malpractice action against the prior attorney, but she will not be able to litigate the merits question again. Now, why such a harsh rule? Because litigation is expensive and time-consuming. We make the defendant go through this process against his will. His prize for doing so is that once the litigation is complete, it's complete, forever resolved. He can go on with his business knowing that he will never have to address this issue again. Res judicata, also known as claim preclusion, has 4 elements, each of which must be met in order to bar relitigation. We're going to go through all of them in detail. Number 1, there was a final judgment. Number 2, there was a final judgment on the merits. Number 3, the claims in the second suit reiterate the claims in the first. And number 4, all parties in both suits are the same. Number 1, you have to have a final judgment. Final judgment for res judicata purposes typically means that the first case is done and the judgment is enforceable. However, some courts have said that a judgment is final for res judicata purposes once the trial court has entered judgment, even though the litigation continues on appeal. You're probably not going to see this fact pattern on your exam, where the first case is still pending on appeal and one of the parties wants to try over in a different trial court. But if you do, it's probably best to assume the res judicata applies. Just apply the regular res judicata test and move on with it. Number 2. Judgment on the merits for res judicata purposes means that the final judgment must actually get to the merits of the claims. If your judgment does not get to the merits of the claims, no res judicata. If a case is dismissed for lack of jurisdiction, it is not an adjudication on the merits. If a plaintiff voluntarily has a case dismissed before the court has the opportunity to rule on the merits, it is not an adjudication on the merits. It means what it sounds like. However, if the court dismisses at the summary judgment stage, it is an adjudication on the merits. The federal courts likewise treat dismissal for failure to state a claim under Rule 12b-6 as an adjudication on the merits, although some state courts are more lenient on that point, on the 12b-6 point. Finally, if the case is dismissed because the plaintiff walks away from it for failure to prosecute, it seemed an adjudication on the merits because the plaintiff had a full and fair chance to litigate the case and decided not to. He chose not to exercise that opportunity. That's deemed an adjudication on the merits, even though it wasn't. That's kind of an exception to the rule, but typically adjudication on the merits means adjudication on the merits. 3, the claims in the second lawsuit must reiterate the claims in the first lawsuit. According to most federal courts, this means that the claims arise from the same transaction or occurrence. As a result, a party cannot get back into a court by making technical changes to his claims or bringing his claims pursuant to a slightly different statute. Any claim that arises from the same transaction or occurrence will be barred by res judicata. That means when a litigant brings a claim resulting from a particular transaction or occurrence, he had better make sure to bring all of his claims relating to that transaction or occurrence into a single litigation, and at the first litigation. However, some courts do apply a different, more lenient test. For example, the Seventh Circuit Court of Appeals looks for claims that arise that are the same factual allegations, rather than the same transaction. The factual allegations test is more narrow and more lenient on the plaintiff. On the losing party, excuse me. A plaintiff will be barred by res judicata if it can be discerned from the facts outlined in the pleadings, but not if it cannot be discerned from the facts outlined in the pleadings, even if it relates to the same transaction or occurrence. That is a minority test, of course. The standard test, unless your professor makes reference to this, is that you're going to use the same transaction or occurrence test. There are other slightly different tests. And unless your professor mentions them, you don't need to worry about them. Understand how significant this discussion is. It means that in many cases, parties will be barred from litigating claims that they never litigated. To illustrate, let's use our hypo from before. When Rachel sues Rebecca under their contract dispute, Rachel claimed all of her damages arising from the dispute, but forgot to claim additional damages relating to her detrimental reliance on Rebecca. The latter claim clearly arises out of the same transaction or occurrence, and using the Seventh Circuit test, might even arise out of the same factual allegations. Nevertheless, despite the fact that she didn't raise that issue in the first litigation, she will be barred from doing it in a second litigation to recover damages for detrimental reliance. Part 4, the fourth part of the res judicata test, the parties in both suits must be the same. Now, it sounds very straightforward, but it's actually a lot less straightforward than it sounds. Some non-parties actually will be barred by res judicata. While no one can be barred from having his day in court simply because he was associated with the prior litigant, someone in privity with the prior litigant will be barred by res judicata. Privity is a word that refers to two people whose interests are so closely aligned that judgment against one ought to be deemed judgment against the other. I'll give you two examples to show you what we're talking about. It should be fairly obvious once you know what we're talking about. Number one, a buyer and a seller of property when the suit involves title to the property. For example, someone goes after the seller of a piece of property relating to the property, whatever the particular dispute is, in a manner that will affect the buyer's interest in that property. The buyer is in privity to the seller. They're technically in privity of contract, and that privity relationship is going to affect them. The second example, parties in contractual relationships where the suit involves the subject of the contract, very similar. In both of these cases, the person who is not a party to the suit, but in privity with the other party, has such a clear interest in the litigation that remaining on the sidelines is just foolish. They stand to lose their interest in the property. They had better stand up and assert their interest now, or they'll be barred from doing it in the future.